Hey, Brian Parker here with another exciting video. This one's a good one. Where have you heard me say that before? This is if you will, it's a generic battle against a debt buyer, but it's against one of the most popular frequent flyers, Midland Credit Management. And I use it as a case study. It's from a member of our site that has some very nice things to say, and I hope it's not too self-serving of me to read this and more of a way to get you to maybe check out killdebt.com for the great value. Let's put up a couple of nice things that the member said before we get started. Shazam. That's the whole page of a Parker testimonial. And he's just basically saying, until one day one of your videos popped up. I didn't know who you were, but the title caught my attention. How to hack a Midland Credit Management collection lawsuit. That was way before I figured out thumbnails, so that's how I wrote. I watched a few of your videos and quickly became a YouTube subscriber. Your explanations were very clear and easy to understand. After about a week of watching your videos, I became a member of killdebt.com and Parker GPT. Woohoo! I really like killdebt.com because your videos break down case documents and explain how to use them to your advantage. And Parker GPT is awesome. All right, yada yada. I'm going to revisit this, show you some stuff. But we're going to do what he's talking about. We're going to break down some documents so that you can see how you can use the breakdown to fight back. So let's look at, we're going to kind of go backwards but then forwards again. Here's the eventual conclusion. Shazam. That is a court saying, hey, member, case dismissed for want of prosecution and prejudice. I guess that's an extra stink on a dismiss with prejudice down in Texas. That's like essentially saying, hey, lawyer on the other side, you really didn't do anything, according to what the member says. And they got their case dismissed with prejudice against Midland Credit. So how can you use what the member did? Well, the member has access to killdebt.com. So do you. Just go there, go nuts, use Parker GPT, go to the Parker GPT, put in your request, press the rocket ship prompt, and that'll give you even better question to make and say to Parker GPT, makes it think more, and then your result comes out even better. So here's what happened in the Midland Credit Management case. This is one of the biggest debt buyers, if not the big. I think they compete with Portfolio Recovery Associates, but they're huge. They buy billions in debt. They keep a lot of people in business. Anyway, the key to this whole case, I'll show you at the end. There'll be 5 key takeaways that you can use in your case. This is very interesting. I want to show you, I've been doing a couple of videos. Let's do one, how to kill a bill of sale. That's up there, been doing that. And we're talking about DOA, debt on arrival. There's another one. And I'm going to show you today how this member on his own figured out how to make this debt on arrival, debt on assignment case end in a dismissal with prejudice against Midland Credit. So let's look at the bill of sale, Shazam. And that's your basic bill of sale that we've been dissecting for the last week or two. You can see the oldie but goodie things there. They're talking about a forward flow agreement that's not attached, yet all the documents refer to the forward flow agreement. For example, at the last sentence of that first paragraph, all capitalized terms used but not defined in this bill of sale. They're telling you right there. So where are they defined? And still have the meanings assigned to such term as the credit card account purchase agreement, the forward flow agreement. The whole thing is pursuant to the forward flow agreement, so therefore you're entitled to it. The bill of sale does not exist as itself states without that forward flow agreement. So touch on that button and that case will go away. But my favorite sentence in all of these bills of sale, look at that last one. The bill of, let's just focus on that, Shazam. The bill of sale is executed without recourse. So what does that mean again? Here, you take this piece of bleep You can't sue us. We're giving this, whatever's going on with this, you can't sue us without recourse. As stated in the credit card account purchase agreement. That makes that forward flow agreement so much more relevant. Oh, they keep referring to it, and now there's legal terms in there. We need to see that. You won't have to go that far. No other representation of warranty of title or enforceability is expressed or implied. So they're shutting down any chance that they say they have title to any of the debts. By the way, the debt of the member is not mentioned, of course. And you can see it's signed by Comenity Bank, June 23rd, 21, and Midland Credit closes the debt out, closes the sale out, 7/21/2021. Remember, a bill of sale is not an assignment. So, what do? Well, we look at this freaking thing. It's very generic. There's no mention of the account number, defendant, or no specific reference, I'll read my own writing, to any particular debt. Point being, an assignment is defined a certain way. It's got to be unambiguous, have authority of the signature, state specific terms like a name, account number that's being assigned. None of that exists, so it cannot be referred to as an assignment in this case. It's pretty much uniform throughout the states. Check your state definitions of assignment versus bill of sale. So I'm going to show you this. You don't have to go to a full form video on the killdebt.com, but please go to killdebt.com. Shazam, here's the bill of sale checklist. So that's a checklist. It's on killdebt.com. It's actually embedded in Parker GPT. So if you said, hey, here's a bill of sale, and you download it into Parker GPT, now go through the bill of sale, it'll do that, and up pops what I did manually, but you can also then go, put this in a counter affidavit, put this in an answer, put this in a counterclaim. See how that beautiful, in this brain and all those documents are embedded in Parker GPT, and you can just produce wonderful answers, counterclaims, affirmative defenses. Just put your law and facts in. So Shazam, kill the bill of sale. So what I did is I looked at, see if we can put the bill of sale, Shazam, and the checklist next to each other. And the first question, is there a forward flow agreement? Yes. Is it being produced? It has not. That's a check. No specific account schedule. Is the account client's name or number in there? No. Check. Is there assignment language saying assignor transfers this debt to assignee? No. Check. Without recourse, no warranty of title disclaimer? Yes. You can win on just on that alone. Check. And now there's boxes where that doesn't apply to this specific bill of sale, but you don't need much more. No assignment words, though called a bill of sale and assignment. Well, no, but there are no assignment words. Check. So as I've written, examine any bill of sale and check off those items that apply and put it into your answer, affirmative defense, and counter affidavit as your defense to the chain of title. It's a chain of title argument, all right? It's DOA, dead on assignments. There are no assignments. Remember, a bill of sale is not an assignment. I almost forgot it. So this all goes into Parker GPT and your answer and counter affidavit. But there's more. They attach to the complaint this portfolio level affidavit of sale by original creditor. They can't even say Comenity. Gee, I wonder if this is a form template that nobody really read. So Shazam. So they're saying that they sold this thing 5/21/2021. This specific guy is some officer of Comenity. My copy's really bad. But let's put up paragraph 5, Shazam, and basically saying, yeah, I've seen it all, and the last sentence is, I am not aware of any errors in the accounts. Okay, as you know, portfolios of debt are bought in the thousands, hundreds of thousands, millions of these debts for pennies on the dollar, and then Midland Credit will tell its affiliated law firms to go sue on all this debt, right? So this guy is swearing under oath that he went through every single thousands of debt and he found no accuracies. If that's true, how come the one thing that's missing isn't in here, the saying, essentially it's being used to attach the complaint to prove that Midland owns it? How come he doesn't mention the name of the actual defendant or the debt or his social security last four or the account number? So, ish don't think so. So, there's another good thing too. Let's put up 5 again. Shazam. Pursuant to the sale, stay with me, seller sold, transferred, assigned, conveyed, granted, bargained, set over, and delivered to buyer and its successors. Now here we go. And assigns good and marketable title to the accounts. Go, leave that up there. Put the bill of sale up there. Go back to the bill of sale. This is fun, and when I get to it. Look at that last paragraph. Now I'm going from memory. The guy has just sworn under oath that good and marketable title is being passed from the seller, Comenity Bank, to Midland Credit. I think you know where I'm going with this. Let's put up the last paragraph of the bill of sale next to that paragraph 5. Let's put it up. See what it says? The bill of sale is executed without recourse, meaning you take this, we're not legally responsible, and no other representation of warranty of title or enforceability is expressed or implied, directly contradicting what that guy says, good and marketable title to the accounts without any specifics. So that's the type of stuff you're dealing with. And one of my tips I'm going to give you at the end of this video will go directly to this. This will all make sense to you. So the affiant, the person that signs off is the affiant, has gone through every account, tens of thousands, and sees no error, but also sees no account that is the basis of the actual lawsuit. So that is that. The affiant claims the debts were sold on May 21, 2021. Yet a look at the bill of sale, let's go at the end, the signatures, Shazam, shows that even his client didn't sign off on it till 6/23, the company he works for, a month later, and then Midland Credit didn't effectuate the sale until 2 months later, 7/21. So there's no sale, obviously. If I sell you a car, to use the car analogy again, you cannot go to the Secretary of State or even sell the car to someone else unless both names are signed on the lines that are dotted. Look up Glengarry, Glen Ross. Anyway, so the complaint states that the Midland purchased the debt on May 21, Shazam. But as you saw, put it next to that paragraph 8, the signatures show that the deal didn't go down, was not effectuated, was not concluded, was not executed, however you want to put that, by that same guy that signed off on the affidavit, Bruce Bowman, didn't sign it until a month after he says the deal went down and all that other stuff. Maybe there were so many documents and so many accounts he didn't have time to sign it when he says it was sold when it wasn't. And of course, Midland Credit didn't somehow not sign off on this till 2 months after this guy says under oath that it was sold. So that's what you have. That's always fun, and that's gonna be part of my 5 tips at the end of this video. I want to show, speaking of fun and boredom all mixed in one, because this stuff is fun for me, but it might be boring for you. But I think when you're facing a lawsuit, nothing is boring. You want to do your best. So you have your, as I always say, your 5-minute pity party, and then you come out swinging. And one of the fun ways, look at this page 1 of the lawsuit, Shazam. I'm just going to read it. It will sound boring. Plaintiff Midland Credit owned portfolios and yada yada. When working with individual consumers, Plaintiff Midland Credit and its affiliates, collectively plaintiff, generally attempt to contact consumers like defendant through several means, all in an effort to establish contact and to resolve the underlying obligation. And then page 2, they just go into this dribble about, oh, we're good guys, we do everything we can not to sue. In the lawsuit, they say this. So they really build themselves up, I think, for an eventual default. So the court can go, these guys are good guys. All they're doing is suing somebody without proving anything. So it is quite a tale there. So through paragraph 7, it's just a story of what great guys they are, nothing to do with liability. And again, we looked at number 8 as the liability, and that was totally false. So let's look at how the defendant answered each allegation. I'm snarky, so I'll go paragraph 1. You're telling us what good guys you are. Actually, it's paragraph 5. What's that got to do with the lawsuit? And you don't own the debt. Paragraph 6, we're really good guys. What's that got to do with the lawsuit and liability, and your chain of title sucks? This client, as I said earlier, went through my YouTube channel, then signed up as a member and went Parker GPT. And one of the number one things I tell you for your great benefit, when you do an answer or any document, and the rules don't disallow this or even encourage this, it just is, you do a preliminary statement. It's the ADHD effect. The poor judge has hundreds of cases to deal with that day. If you can do a spark and shine and look different and give that judge a 30-second to a minute synopsis, you're likely going to do much better than the attorney that's not even on the file, that just did it as a favor or as a contract and doesn't know what he's doing. So that's what this client did. But look at this, page 1. Showed the judge. Bill of sale, closing statement, signed affidavit, filled data sheet. So as I always preach, you look for the linchpin, and that in that case, that was number 8 of the lawsuit. You take away that, you take away everything, and the member did a great job, but you use their documents against them. And he front-loaded. He said, court, this is what we're going to be relying upon, their stuff. And then he did what he called an opening statement, preliminary statement, however you want to frame that. And look at that beautiful job. He's just telling the court right off the bat why they're bad, why they don't have any proof. The bill of sale provided by plaintiff does not contain my name, account number, or any reference to specific debt, and it refers to a purchase agreement that's not been submitted as evidence. That's his beginning. And then page 2, Shazam, keeps going on with his preliminary statement, and he marked it in blue so it goes to the eye. My early videos I always used to say, put a pink sticky note. Well, that's the same thing. Draw someone's attention to it right off the bat in that 30 seconds to 1 minute. And you do that, by the way, when you're giving an oral argument, you're a pre-trial or there's a motion, that 30 seconds to 1 minute is so important. I just did this on a circuit court case, big one. I started out, Your Honor, this case is DOA. And I saw the pause on his face, and I said, dead on assignments. Just remember, a bill of sale is not an assignment. So that's pretty impactful, because now you're, what? Dead on, what is going on? And then I laid down quickly why, in this case, LV&V funding sucked. And we won that. The court dug into their stuff. Well, Mr. Parker says this is missing. We did so well that day. I'm a little embarrassed to tell you this, but I'm also happy. The judge found a entity or owner that I had missed. There were so many. He went into the attorney and said, well, I've just noticed that it was a SoFi case. Where's the ownership interest? Who gave SoFi Lending Corp this debt to give to LV, to give to Resurgent, to give? So I made such an impact, I think, at the very beginning when people are most attentive. So debt on assignments. A bill of sale is not an assignment. Now I have your attention. Boom, 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 boom. And we won that motion handily. By the way, whenever you go into those type of motions where they're doing a motion to dismiss, they assume they're going to win. The look on their face when they lose, like, how the heck did... You can use all of my stuff in Parker GPT, and I want you to. As this member did, let's go to his 3rd page. And that's, again, he's highlighting, and he's being respectful. Your Honor, at this time, I'm unable to confirm or deny whether the plaintiff is duly authorized to conduct business. That is so, because one of their paragraphs says, we're supposed to be in this jurisdiction. Where's the proof of that? And my point, and this member listened to me, you don't let them get away with anything. You even dig into them when they say, we're in the jurisdiction because we're allowed to be here. Oh yeah? Where's the proof of that? It just builds a giant wall that eventually falls on them, and you can just get the judge to push it. So this member did a great job. I want to give you 5 takeaways so I can end this nonsense. Excusez-moi. Here again is the court's decision. Order of dismissal, case dismissed for want of prosecution. And here is what the client said in his letter. This is how you know a member is really confident and did a good job. Let me put this up there. Shazam. I almost felt sorry for the plaintiff's lawyer. He wasn't the original lawyer listed in the summons. I believe the original lawyer passed the case on to a younger attorney after we served him the counterclaim and pointed out all the flaws in MCM's documentation. By the way, that's true. I just did a case where I pointed out such really bad things. The attorney that's been on the case for day one for almost 3 years, a big case, didn't show. Suddenly he was out of the country or something. And this poor attorney showed up and just slaughtered him. So, but that's how confident, forgive me, Killdebt.com and Parker GPT made this member, where, you know, you go from, oh shoot, I'm being sued, to he's looking, oh, this poor guy, I'm going to kill him today. There is so much to be said there. No matter what you do, be confident. And some people say fake it till you make it. That's not true. You can't fake it. Especially, I've been in front of juries. If you're not who you are, they see right through you. Just as if I was fake with you, juries are just human beings. All right. So the way to be confident is to really know your. That's the best advice I can give you. Like when I do this video, I've read this freaking thing, I've corrected. I go on ChatGPT and say, hey, give me a skeleton, and then I fill in everything I need to do. Then something else comes up, then I find a new line of inquiry. It's really hard work to get, but by the time I'm done, I could do this without looking at it. But I also don't want to miss stuff. So he felt sorry for the other side. The younger lawyer tried to put up a fair argument, but he was doomed from the start. Ready what he says? He was DOA, dead on assignments, dead on arrival. I got to tell you, I didn't tell or write or have any part of what somebody, I will tell you, if you have a case and you want me to look at, I won't give you legal advice, but I'll do a video on it, how I would do it. Or if you succeeded, please send it to me. These are this person's own words. It's just lovely. I want to thank you for what you do for your audience. It helped my wife and me tremendously. If I can give one piece of advice to anyone being sued, don't give up. He's right, and there's a confidence in there too. Don't be one of the 9 out of 10 people who default. Be the one of the 10 who fights. And then he says, while we were waiting outside the courtroom, the bailiff called 3 different names, but no one answered. I guess they didn't showing up. Showing up is 90% of the game. You got a chance if you show up. So here's your 5 takeaways. Shazam. Always examine the bill of sale carefully. Look at your specific account information. Use that kill the bill of sale checklist that's on Killdebt.com. Second, understand the burden of proof. Simply put, they have to do all the work, but if you take their documents, and they're usually bleak and bad, you can use them against them to show that in the chain of title, they legally don't own the debt. Number 3, read everything, then read it again. Stuff always shows up. I am not a smart man. I'm not a genius or any of this. I'm just in my lane, and I've done my 10,000 hours, as some people say is required to succeed at something. Although I can't play guitar, and I've put more than 10,000 hours in it. I can't, especially in this world of quick fixes and links. As I was getting older as an attorney, I thought, I'm going to get my butt kicked as far as when the new generation comes in. But what I've noticed is my brain, just a tiny bit slower, is still great. And the more I read, the more I ingest. And I look over, and they're doing the C thing. And the C thing is their body is in the letter C on their laptop or talking from a phone. I know they haven't done the work. And so the beauty of ChatGPT is that it it loosens the cap, but you still got to do the work to take the cap off and then do the work of whatever it is you're trying to get inside. So you got to, I'm telling you, you want confidence? Read again, then read again. I've been in trials where I'm reading something, oh my God. And it's a year later from when I first got the case. I'm like, this changes everything. I've had one of those moments. Read again, and read again. That will give you confidence, because things will just pop up after going through my killdebt.com where you go, he's right. Not that I need to be right, but I need you to be right. Fourth, don't assume the debt buyer actually owns what they claim they own. They don't. Assume the opposite. And what I want you to do, pretend to be them. By the way, a good trial attorney knows everything about the other side. So pretend to be them arguing their case, trying to fill in the blanks that they've created for themselves. Again, I always butcher this. Know yourself, know your enemy better. And that's what they have to go to war with. They have slings and arrows because you've got drone missiles. So be them. Pretend to argue their case. And I do it all the time. I've been in trials where he says something wrong. I go, you're right, he meant to say blah, blah, blah. And I'm like, Parker, you idiot. But I know the case so well, I start helping the other side just to get this thing moving along where I want it to go. Anyway, fifth, fight and don't assume that a lawyer on the other side knows what they are doing. Please, never underestimate your opponent, but it is a fair assumption to believe that they have no idea what they're doing. You'll hear it. I have a case that's 3 years old. They're still using the name my client hasn't used in 15 years. That is pervasive in the plaintiff collection industry. There's just too many cases. The people that work those cases are not enthusiastic, driving to work as fast as they can because they just love this job. They want that job to be over as soon as they get there. So you do the work. Again, don't assume that the debt buyer owns the debt. Assume the opposite. Conclusion. Read what that member had to say. It's all true. He did that. With this video at killdebt.com will be all he said, all his documents, extensive show notes. I'll give you the whole answer. The answer went, I think, like 13 pages. You don't have to do that, but you can take parts. It's there for you to use at killdebt.com, powered by Parker GPT. You'll see. Kill the bill of sale checklist. I made that 5 videos ago. I keep bringing it up in new videos. It's so great doing this stuff. Every day I go, oh, wait a minute, bill of sale. Let's blow that thing apart and show people. Now I got a checklist for you. And I'll throw in a validation letter, as this member used, to send to MCM. A lot of times you do that because MCM may give you stuff or give you the wrong stuff, or just being honest, that's different from the attorney who hasn't done the work and doesn't do the work. He's got 160 cases. So use that letter, use this video, use the member's great success, and have your own. I can't promise you anything, but I can definitely promise you every weapon you need to do your fight with your facts and law will be on killdebt.com. Go get them.